What's up, everybody? What's up, everybody? Welcome to the live. Welcome to the live. Everybody get in here. Everybody get in here. We've got some motions to get into. Well, some responses to motions to get into, some various filings, but today was the day. Today was deadline day before the big hearings begin next week. That's next Tuesday at 8:45 a.m. Atlanta time. The new judge in the YSL Young Thug trial is going to be taking the reins, and we're going to be seeing some substantive motions, finally, some substantive decisions from her. The defendants will all be in court, and she's going to start taking up all these motions that were filed. But let's see. There's been various things filed. Weinstein did send me his response to the gag order request. I know that was earlier today, so it's been kind of making the rounds, but he quotes Winston Churchill in there, and then also quotes Fani Willis herself, the press conference in May, announcing the decision, or announcing the indictment, talking about kind of calling her out on the hypocrisy there. But let me pull that one up. Steele has a bunch of new stuff in too. It's going to be really interesting to see how the judge approaches all this stuff on Monday, because there's just been a ton of stuff filed. New stuff. The motions for mistrial, and there are various motions for mistrial. I think the strongest argument, the most argument one is the most obvious argument for a mistrial comes from Bruce Harvey in his motion, just talking about the logistics of a new judge coming into such a complex trial, like 19 months in, 6 months into testimony. But remember, that's the motion that doesn't seek a with prejudice dismissal, because a with prejudice dismissal usually requires some kind of prosecutorial misconduct finding, and just a situation like that would leave the door open for a mistrial. The mistrial that Harvey's talking about, that would leave the door open for the prosecutors to retry them. So Steele filed something today specifically stating his opposition to it, because it's without double jeopardy attached, without prejudice. But I still think it's probably it's their best argument, because the other stuff really involves Woody's testimony having to be rewound could be an issue, but the other stuff really involves the judge needs to rescind Judge Krause's order about the ex parte and make her own finding that it was improper. And I'm not sure she's going to be willing to do that, but if she does, it'd be really major. Well, we'll see what happens with that. But let me pull up Weinstein's motion, and he, as we talked about the other night, he doesn't think this gag order really has any chance. And the big difference is, because we've all heard of gag orders before, and of course they do happen. A judge does have the ability to restrict that, but it's usually before a jury has been seated, and you're worried about people who don't even know that 6 months from now they're going to be called for jury duty are reading and articles and watching newscasts of the case. So they're trying to prevent prejudice that way. But after the jury's been seated, having a gag order like that is pretty rare. So hello, Breaking It Down with B. Thank you for saying hi. Thanks everybody for saying what's up. So Kendrick's opposition to state's motion to restrict extrajudicial statements. But Sir Winston Churchill, I know a few people who would be glad to see Winston Churchill quoted here. Everyone is in favor of free speech. Hardly a day passes without it's being extolled. But for some people's idea of it is that they are free to say what they like. But if anyone says anything back, that is an outrage. And then this is Fani in August 2022. I think if you decide to admit your crimes over a beat, I'm going to use it. I'm not targeting anyone. You do not get to commit crimes in my county and then get to decide to brag on it, which you do that for a form of intimidation and to further the gain and to not be held responsible. She said that in August 2022 at a press conference. So he's kind of pointing out the hypocrisy of it all before he gets into it. But again, this is probably the least consequential of, at least trial wise, of the motions. But it's representative of a few things. It's symbolic, and of course, if she were to grant a gag order, it would change obviously the public comments that we hear. We wouldn't be hearing any public comments. But again, I don't think she's gonna grant it here. But we'll see. It says free speech for me, but not for thee is the current position advocated by the Fulton County District Attorney. This should not be surprising to anyone that has paid attention to the present case over the last 19 months of trial. The state would apparently like the present trial to be conducted in secret, with proceedings happening in hidden chambers outside the prying eyes of the press and the public. The state has repeatedly sought the secreting of witnesses' identities, even in instances where the state has made no showing of risk to the witness, despite the court's order that such showing be demonstrated prior to blocking the broadcasting of witness testimony. After attacking the integrity of respective counsels for defendants and witnesses, e.g., repeatedly calling the Honorable Brian Steele a liar and accusing the Honorable Jonathan Melnick of working for defendants rather than his client, Kenneth Copeland, the state now turns its attention to counsel for Diamante Kendrick. Typo there. But to paraphrase President Truman, counsel does not give the state hell. Counsel just tells the truth about them, and they think it's hell. It's a 1.5-page motion. In a 1.5-page motion, the state cites to Rule 3.6 of the Georgia Rules of Professional Conduct and cherry picks certain comments to the rule to support its motion to, quote, instruct the jury to refrain from making, to instruct the defense, to refrain from making extrajudicial statements about this case moving forward. No case law is cited. No finely tuned order is proposed. As the state accurately quotes, Rule 3.6 bars lawyers from making extrajudicial statements that a lawyer knows or reasonably should know have a substantial likelihood of material prejudicing an adjudicative proceeding in the matter. The state provides no specific quotes of Kendrick's counsel that might be barred by Rule 3.6. Instead, the state invites the court to go on a scavenger hunt among 208 minutes of interviews to find statements by Kendrick's counsel that might arguably violate 3.6. The court should decline this invitation. Remarkably, the state does not make a single argument that any statement by Kendrick's counsel meets any of the elements of 3.6. Instead, the state simply offers up a single conclusive statement. There is no argument that any statement made by Kendrick's counsel was known to or should have been known to have a substantial likelihood of material prejudicing the jury. No argument was made because no argument can be made. The present jury has been impaneled and hearing testimony for months before any statement was made. The jury has been instructed at the conclusion of every day of trial by Chief Judge Glanville through his ad nauseum admonitions to not discuss the case with others or with each other. They have been instructed daily to not consume any media about this present case. No statements made by counsel for defendants can be heard by the jury to prejudice the jury. The state invites this honorable court, which is trying to catch up on hundreds of orders, many of which are provisional, 19 months of trial, over 100 days of testimony, and testimony from almost 100 witnesses, to wade through hundreds of minutes of interviews, find statements of Kendrick's counsel that might be objectionable, determine what Kendrick's counsel knew or should have known, and summons a reason about why and how they could material prejudice a jury that is barred from and admonished on a daily basis from consuming media about the present case. This honorable court should respectively decline this invitation. In addition, the state conveniently fails to quote from the presumptively safe harbor comments included in Rule 0.6 that permit Kendrick's counsel to speak in public on his behalf. Comment 5BA reads that, quote, there are certain subjects which are more likely than not to have a material prejudicial effect on a proceeding. Thus, a lawyer may usually state information contained in a public record. Each statement made by Kendrick's counsel relates to publicly available information in the public record of the present trial, which is being streamed daily to the public. To the extent there are any remarks not specifically in the public record, such statements are general remarks intended to demonstrate that Kendrick should not be on trial. Justice Kennedy rightfully understood the present situation that Kendrick and his counsel find themselves in. Kennedy wrote that an attorney's duties do not begin inside the courtroom door. He or she cannot ignore the practical implications of a legal proceeding for the client. An attorney may take reasonable steps to defend a client's reputation and reduce the adverse consequences of an indictment, especially in the face of prosecution deemed unjust or commenced with improper motives. A defense attorney may attempt to demonstrate in the court of public opinion that the client does not deserve to be tried. Justice Kennedy also correctly notes that the police, the prosecution, other government officials, and the community at large hold innumerable avenues for the dissemination of information adverse to a criminal defendant. And this is back in 1991, before the days of the internet. By contrast, a defendant cannot speak without fear of incriminating himself and prejudicing his defense. And most criminal defendants have insufficient means to retain a public relations team apart from defense counsel for the sole purpose of countering prosecution statements. There you go. Justice Kennedy cites the important role that defense counsel plays in educating the public on pending cases, writing, "Because attorneys participate in the criminal justice system and are trained in its complexities, they hold unique qualifications as a source of information about pending cases. Since lawyers are considered credible in regard to pending litigation in which they are engaged and are in one of the most knowledgeable positions, they are a crucial source of information and opinion. To the extent the press and public rely upon attorneys for information because attorneys are well informed, this may prove the value to the public of speech by members of the bar. If the dangers of their speech arise from its persuasiveness, from their ability to explain judicial proceedings, or from the likelihood the speech will be believed, these are not the sort of dangers that can validate restrictions. The First Amendment does not permit suppression of speech because of its power to command assent." This is the exact situation that Kendrick and his counsel find themselves in today. Kendrick is a public figure who is an artist. He writes, records, and performs rap music and lyrics. In Fulton County, this makes Kendrick a target of the state. Kendrick is allowed to take reasonable steps to protect his reputation, and those steps may be taken by his counsel rather than through a public relations firm. Having smeared Kendrick and his reputation, the state wants to silence him. Initially, by placing a burden on his free speech rights to write about the world in which he lives and the tragedies and injustices around him. And now, by holding press conferences denouncing him and his writing, while subsequently seeking to bar him from defending himself in the court of public opinion. While the state has unfortunately been successful in impermissibly burdening the free speech of Kendrick by limiting his present and future writing, the state should not be allowed to bar him from defending his reputation. And that's the end of it. Yeah, I mean, I really don't see the gag order as being viable, but who knows? That's definitely not the biggest issue on our plate. Like I said, it was probably the most interesting one to come up just because it was unexpected. I mean, we all know the mistrial and the bail motions are going to happen. But let me see. Let's bring up Brian Steele's big guy. What did he file here? It's Mr. Williams' response to state's motion to restrict extrajudicial statements filed on July 23rd, 2024. Oh, you know what? I wanted to, because Weinstein's right in his response that they don't explain in their, prosecutors don't explain in their request for a gag order, like why certain statements are wrong, but, and they do invite the scavenger hunt where they're like, hey, listen to all these interviews and, find stuff that's wrong with it. But they also, the prosecutors did identify timestamps of statements that they apparently took issue with. So I went through, and I played this in the last live, but I went through and played it for, put together a mashup of the statements. So these are just the examples that prosecutors cited that they're apparently so worried about, but it's here.
In reality is Shannon, I'll say it today, I'll say it tomorrow. He is innocent of the charges in this indictment.
Right, because again, I think we're winning. I don't think, as you said, I don't think any jury right now, even without us presenting any case at all, a jury could find RICO violations. A jury could find murder. Now they're in the middle of their murder case, but I don't think it gets any better for them. I don't know. I mean, that's their call. I mean, I don't think their case is very good. Do they want to retry this? Do they want to indict it in a different way? I don't know what they're going to do. I really don't.
We don't need prosecutors doing unethical things and trying to trick the court or be dishonest to the court. We want everything to be fair, and we firmly believe that if everything is done the way it's supposed to be done, if it's a fair, unbiased part of the trial, that Jeffrey Williams is going to walk out of that courtroom a free man. He's going to be exonerated of all of these things that he's been wrongly accused of.
I think at the present time, I think the trial's going very well for us. I think anyone that's been watching this can see that the state hasn't come close to proving any of the charges against Mr. Kendrick. Beyond, he's accused of serious crimes that he did not commit. Mm-hmm. So to the extent that the public can watch what's going on and learn and see the case that the state thinks that they have against him. And of course, it's ultimately it's up to a jury to decide and see that Mr. Kendrick is not guilty of these crimes. So we've always felt that if we get a fair trial, we're going to get a not guilty verdict. Mm-hmm.
So yeah, again, that was a mashup of the comments that prosecutors cited in their motion for a gag order. That's apparently what they take issue with. But let's gonna bring up Brian Steele's response here. It's like a hefty one. He included the entire transcript for the motion or for the ex parte as a response here, but. So this is the response to the gag order request. A motion to adopt motion for fair and constitutional trial. If you remember that's the motion that Max Shard filed, where he specifically states that he doesn't want a mistrial unless there's double jeopardy attached, because it's not in Stilwell's best interest to just have to start over. So that's this motion here that's on the screen is Brian Steele saying, I want to be part of that motion. And also specifically stating that he doesn't want to be part of Cormarvius Nichols, that's Bruce Harvey and Nicole Westmoreland, part of the Bruce Harvey motion for mistrial, because it doesn't have a with prejudice finding attached. And remember, we talked about that earlier. I think it's the most persuasive mistrial motion, but legally it wouldn't be a basis for prejudice. Usually you have to find some kind of prosecutorial misconduct or something specific to the case. And Harvey's motion is just all about really the logistics of a new judge coming in and trying to take over a trial like this. And like I said, I think it's totally persuasive, but I can understand why the other defense attorneys, out of interest for their own clients, don't want to just start over like that unless they're, and they don't want a mistrial unless there's some kind of guarantee that they're not going to start over, that they want the case just to end, Says Mr. Williams' counsel's statements referenced in the state's motion do not violate the plain language or spirit of any ethical rule. In contrast, the state failed to alert this honorable court that before and during jury selection, when the potential jurors were not fully charged to avoid all media reports concerning this indictment, the following occurred. And yeah, I mean, in here, this is even better than Weinstein's motion where he quoted Fani. Here's an exhaustive list of like all the public comments that prosecutors made, like Steele points out, before the jury was impaneled, because that's when you usually have gag orders, or maybe not even usually, but always. But because, you have people just existing in Atlanta who don't know that, a year from now, they're actually going to be called for jury duty on this. So you can't reasonably expect them not to consume media about it. But Monique, thank you so much for weighing in and for tuning in. I appreciate it. Always love the super chats. You guys make it worth it, and I love keeping everybody informed. There's just so much being filed, and I've said this before, but definitely follow Thugger Daily, the account on Twitter, and also Joseph Papp from Atlanta Journal-Constitution. He's got he has a paper to write for and a website to write for, but he also stays up on the court documents and keeps up on everything. But there was a lot of stuff filed today, and I know Thugger Daily has some really organized threads on everything. So if you guys want to get the actual documents there, but if you'll see this, Steele is just going through, all the public statements that Fani Willis has made. I mean, here's a link to her press conference. Gosh, I'm not sure I want to see this, but you know what? Maybe we should. I don't think I've ever seen this. This is before I was really paying attention to the case, but should I put it on? There we go. So what, she speaks at 11, they say?
Utilizing our tactical teams, we were able to go out to the individual's location and arrest him without any significant consequences to him or any other parties at the house. And so with that, I'll turn it over to the DA.
Thank you, Chief Bryant. Today, I'm joined by the Atlanta Police Chief, Chief Rodney Bryant, as well as my sheriff and our sheriff, Sheriff Patrick Labatt. We are here today about a grand jury indictment that was returned that included not just Jeffery Williams, which is of some notoriety and media attention, but about 28 defendants that operated within our community between the time period of 2012 and 2022. It is our allegation that they operated as a criminal street gang and commenced to do havoc in our community. That havoc includes crimes of violence, crimes of thefts, crimes involving drugs. I've made no secret about it, nor any apology that as the district attorney of Fulton County, my number one focus is targeting gangs. And there's a reason for that. They are committing conservatively 75 to 80% of all of the violent crime that we are seeing within our community. And so they have to be rooted out of our community. I said just a week or two ago, it does not matter what your notoriety is, what your fame is. If you come to Fulton County, Georgia, and you commit crimes, and certainly if those crimes are in furtherance of a street gang, that you are going to become a target and a focus of this district attorney's office, and we are going to prosecute you to the fullest extent of the law. I agree with Chief Bryant. What you see yesterday and what you will see in the upcoming months and years is the result of a lot of hard work by both the Atlanta Police Department and this office. We are proud to bring forth this indictment and hopefully to bring justice to a lot of the community who was victimized through the course you see in this indictment. But more importantly, the most important thing that we are here to do is to keep this community safe. And we believe removing these 28 defendants will keep Fulton County safer.
Well,
yes, sir.
The indictment's got Young Thug and a bunch of other rappers. There was one name I was actually expecting to see there that I didn't. That's Jeffery. Can you speak to that?
What I'll tell you is that as large as this indictment is, I told my team that let's not be sexy, now let's not overreach. Let's be conservative in our approach, which is always the approach that I take. And in taking that approach, 28 defendants were indicted, and they were indicted for the crimes that I believe were appropriate for this RICO indictment. And so I won't speak to any person that is not named.
In terms of serious, significant charges, I would imagine you're going to see some pretty serious sentencing here. I know it's early, but can you talk a little bit about the type of sentences they might be facing?
We'll ask on the different charges for the maximum penalties, and there's obviously many people that are looking at life under this indictment. You're absolutely right. These are serious times. They're serious allegations, and it is my opinion that violence in our community deserves maximum penalties.
In a recent interview, you said in the coming weeks and months to expect indictments, RICO charges, gang charges. We see that with here, but this is only focused on the YSL gang. At that time, you used plural indictments. Should we expect more indictments against singular gangs in the coming weeks and months? Is that what you were meaning with that quote?
Yeah, and if you're already aware, we dropped an indictment not that long ago against YFN. It is certainly a tool that I believe in, which is using RICO. I believe the reason that I believe in it as a tool is it allows juries and the communities to see the complete picture of a crime so they can truly be educated and have facts to weigh when they're making decisions. And so if you're asking, should you expect to see other RICO indictments against other street gang organizations? Absolutely.
Two questions specific to YSL. The 20-some people arrested here or named. How big is this gang? Is that a good portion of the gang you're operating in Atlanta? And how long were you investigating them?
If you look at the indictment, the crimes that are alleged within it go all the way back from 2012 to 2022. I wouldn't say that it contains every act of crime that YSL committed. It is a significant gang that operates here in Atlanta, Georgia, and not every member became a defendant within this indictment, but certainly a significant amount did, and certainly some of the leadership, which is what's most important. We're not going to just target the children that are running out at the direction of leaders and not target leaders.
How much did social media, music play a role in bringing this indictment?
Social media is a wonderful tool for prosecutors in every indictment we bring nowadays.
And let's talk about, obviously, YSL. There are the territories at Cleveland Avenue, no secret. We've seen a ton of violence, innocent bystanders get hit. So you guys believe that by getting them off the streets, that people in that neighborhood who are living in fear could actually have some peace now?
I believe that people in that neighborhood and at every corner of Fulton County deserve to be safe, even if it is financially lower, socially, economically. You know, I don't think that part of the community should be left behind. Me and the mayor and the police chief have talked about the fact that Cleveland in our community is referred to as Bleveland, that it is somewhere where just violence occurs, where they're marking up territory, it's blood territory. It's horrible. And you're absolutely right. That community deserves to be safe, and we are hoping that this helps to keep them safe.
Let's talk about safety. You know, these gang members are going to be housed or brought in at the same time. How are you and Sheriff Labat working to keep them away from each other in the jail, especially with YS and Lucci being a targeted incident that came out?
Well, I won't step outside of my lane. I am the district attorney of Fulton County. I am not the sheriff. I have great confidence in the sheriff. He knew that this was coming as a law enforcement partner, and I believe that he is well prepared, but you'd have to speak to him to make sure that everyone within his facility is safe.
This indictment names a few, it's not just social media posts, but songs that have been released by Young Thug and others, where those people's lyrics evidence supporting the RICO conspiracy. And I'd like you to speak to the First Amendment issues that obviously right.
This issue's been ruled on by the courts. I knew that question was coming. I believe in the First Amendment. It's one of our most precious rights. However, the First Amendment does not protect people from prosecutors using it as evidence if it is such. In this case, we put it as overt and predicate acts within the RICO count because we believe that's exactly what it is.
Let's allow Sheriff Labat to answer.
I have one more from What's the last time you prosecuted a RICO case? Was that the APS case?
This office? No, since I've been here as the district attorney, I think we've indicted probably 4 or 5 RICOs at this point. So it's a tool I use.
First of all, good afternoon. I believe both Madam DA and Chief Bryant are really raising the level of consciousness in what we're doing within Fulton County, and certainly they deserve our appreciation. With respect to the specific question as to safety and so many people being brought in, we are housing them accordingly to include other facilities. So I encourage everyone to really download the Sheriff's app if you want to know specifically where individuals are, and you'll be accommodated accordingly.
Sheriff Levine. So like I said, jumping to the indictment, there was an element of it where they were talking about Montavious career into with an inmate, where the inmate had a cell phone that was contraband. But it was clear from the indictment that you had been, or that all of you had been monitoring that conversation. Like, it leads me to ask a question you're probably not going to answer. Was that cell phone deliberately given to an inmate so that those conversations could be monitored?
So I did have an opportunity to read your editorial that you posted in the Buckhead blog or whatever it was from that perspective. And so you're right, I'm not going to answer it. So, appreciate it. We'll leave that to Madam DA.
Can you tell us about the 28
20 back.
how many have been arrested, how many are large, how many are already in custody?
And I do not have that exact number. I can tell you approximately 10 were already in custody. I believe as of last night, we had arrested at least 3 as of last night. I expect to see more arrests today and in the upcoming weeks, but I'm realistic. It's probably
This is from 2000.
the next 2 weeks to get everyone in custody.
There's been some discrepancies about where the gun is. Maybe this is better for the sheriff. Where he's being, is he in custody?
Here, it's a little hard to hear, and they're asking out-of-date questions. But that was the press conference from May 2002. Oh, I see Slick So Famous calling me out for highlighting my own comment. I just wanted to make sure that, like, when people drop in and they saw that press conference, they wouldn't be like, is this going on right now, But no, that was from 2002. But that is, Brian Steele quoted that heavily today in his response to the request for a gag order. And let me pull that back up here. He quotes it up there. He also quotes from George and Christina's old podcast about the case, because Fani went on there during voir dire too, before testimony began, but when the jury panel had still, or the potential jurors had been identified, and she still talked. So that was the press conference we just watched in May 2022. And Brian goes through and quotes a bunch of stuff. But then there's the King Slime podcast that Christina Lee and George did together. I guess they're not doing it anymore. But I'll to save time, I won't go through and listen to all of that too. But Brian Steele goes through and quotes all of Willis's, a lot of Willis's statements in there. And then he says, and what's notable is that he stopped using the word honorable to describe Love Hilton in Glanville. He made a point of using honorable to describe George Shedd. He called him the honorable reporter, but he makes a point now, this is Brian Steele, of calling Adrian Love and Simone Hilton Lawyer Love. Lawyer Love's motion to restrict extrajudicial statements must be rejected. It is rich, audacious, and hypocritical that the state seeks to critique as unethical the single statement by Mr. Williams' counsel, which contains accurate factual assertions. And again, remember, Doug Weinstein has talked a lot. Max Shard has done interviews. Keith Adams did the interview with Sylvia, but Brian Steele hasn't talked at all. And of course, you'd be. Of course, people have tried, but his one statement that they brought up was the statement that he released the day that Judge Glanville was recused. It was just like one of those emailed statements that I'm used to getting from PR people in my inbox, but they included as an exhibit. Let me pull it up for you guys so you can see it. The DA filed it as an exhibit in their request for a gag order. I'll pull it up just so you guys can see exactly what they're talking about here. It's here. You can tell. I think it's as posted by Thugger Daily, and this is the statement. The one statement that they take issue with from Brian Steele is Jeffery Williams is innocent of the charges brought in this indictment, and to clear his name, he sought a speedy trial, one in which he would receive the constitutional guarantees of a fair trial with an impartial judge presiding and an ethical prosecutors following the law. Sadly, Judge Glanville and the prosecutors have run afoul of their duties under of the law. Mr. Williams is grateful that the reviewing court agreed with him and entered the order recusing and disqualifying Judge Glanville from presiding over Mr. Williams's case. We look forward to proceeding with a trial judge who will fairly and faithfully follow the law. So that's the single statement that they have, that prosecutors have from Brian Steele that they took issue with. So Brian Steele is saying, it contains accurate factual assertions. This is his response that was filed today to the gag order. He says, as an overarching principle, Rule of Professional Responsibility 3.6, Comment 1, makes clear that just like the framers of the United States Constitution envisioned almost 250 years ago, when they mandated that those accused of crimes are guaranteed the rights to a public and speedy trial. Here's the quote. There are vital social interests served by the free dissemination of information about events having legal consequences and about legal proceedings themselves. The public has a right to know about threats to its safety and measures aimed at assuring its security. It also has a legitimate interest in the conduct of judicial proceedings, particularly in matters of general public concern. Furthermore, the subject matter of legal proceedings is often of direct significance in debate and deliberation over questions of public policy. I like it. Especially as a courts reporter, you can't argue with that. But moreover, comments 5A and 5B delineate certain subjects about which a lawyer could speak, which are more likely to have a material prejudicial effect on a proceeding. And those subject areas are more likely than not to have no material prejudicial effect on a proceeding. In a criminal case, comments which are more likely to have a material prejudicial effect on a proceeding include subjects related to, one, the character, credibility, reputation, or criminal record of a party, suspect in a criminal investigation or witness, or the identity of a witness, or the expected testimony of a party or witness. 2, the possibility of a plea of guilty to the offense, or the existence of contents of any confession, admission, or statement given by a defendant or suspect, or that person's refusal or failure to make a statement. What is more relevant to the issue at hand is the commentary relating to those subject areas more likely than not to have no material prejudicial effect on a proceeding. These subject areas include, 1, information contained in a public record, 2, the scheduling or result of any step in litigation. And this goes to Weinstein's defense on it too, that he was commenting on stuff that's already in the public record. And it says every factual allegation in the statement made by Mr. Williams' counsel is contained in the public record. Specifically, Mr. Williams has repeatedly, in public filings as well as by and through his counsel in open court, maintained his innocence. Mr. Williams filed a motion for speedy trial. The recused judge, Lawyer Love and Lawyer Hilton, have been accused of and found to have run afoul of their duties under the law. I'm not sure if... I'm not sure what judge has found them to be afoul of their duties under the law. I mean, that's what Steele is hoping for, but Judge Krause didn't find that. And Judge Glanville has been recused and disqualified from his role as trial judge based on a motion brought by Mr. Williams. As this honorable court is aware, Mr. Williams' trial is televised live from gavel to gavel, except there's no actual gavel. The coverage is available to the public at the click of a link, even when not watched live, as recordings are maintained on YouTube. Thus, the likelihood of Mr. Williams' counsel's repetition of information in the public and or findings of the court could material prejudice in adjudicative proceeding in the matter is absurd. Moreover, the jurors in this case have been provided cautionary instructions and admonitions countless times, at least daily over the 100+ days of trial, not to listen to anything related to this case. So, unlike pretrial comments, which the state is guilty of making, there's no basis for Mr. Williams' counsel to believe that his statement will have a substantial likelihood of material prejudicing in adjudicative proceeding. Yeah, and this just goes back to what I've talked about earlier with the fact that when you hear about a gag order in a case, because those are, I don't know if they're common, but we definitely hear about them. It's before a jury is impaneled, because it's when a high publicity case has just started and there are people in the community who don't even know that 6 months or a year from now they're going to be called for jury duty for this. So you're trying to limit that. But when you already have a jury impaneled like this, like, that's a pretty central argument that a gag order is not necessary. But and then here's Steele's argument for adoption of Mr. Stillwell and Mr. Kendrick's motion for mistrial only if this honorable court finds that Mr. Williams was goaded into moving for mistrial based on prosecutorial and judicial misconduct, and thus retrial is barred. And that's crucial. You have to have some kind of misconduct finding usually to bar mistrial. It says Mr. Williams has been forced to remain in custody while the recused judge and lawyers Love and Hilton violated Mr. Williams' right to a fair trial, fair tribunal, right to due process, right to confront witnesses, and the like, causing Mr. Williams to be goaded into moving for a mistrial, as demonstrated by a few examples as follows. Mr. Williams was denied his constitutional right under the Georgia Constitution and federal Constitution to be present at critical stages of this proceeding. And that's, of course, referencing the June 10th ex parte, the now infamous acts of June 10th, involving the secret chambers meeting with the judge and Woody Kenneth Copeland. In the case at bar, the recused judge, lawyer Love, and lawyer Hilton unlawfully influenced Mr. Copeland to testify against Mr. Williams. And they're citing, they've got the whole exhibit cited here. And then I think exhibit B is probably that affidavit that they filed a while back that goes that goes through the transcript and lists like everything wrong with it. And we've already seen that, but I bet they filed that too. We'll see. Under the federal Constitution and Georgia Constitution, Mr. Williams was prejudiced by being wrongly excluded from the critical stage of the proceedings where Brady evidence, and that's potentially exculpatory evidence, judicial misconduct and prosecutorial misconduct was captured and intentionally concealed from Mr. Williams and his counsel. Yeah, because they never told him about the meeting, and he confronted him about, Steele confronted Glanville about the meeting, a couple hours after it happened. Weinstein told me early on that he wasn't willing to say that Glanville was never going to tell him about the meeting, but I'd be willing to say that. But I mean, we'll kind of never really know. But the rules on ex parte, or the guidance for the judges, is that they let all sides know immediately about any ex parte communication. And I don't think that what Glanville's gap in anything there counts as immediately. But they're talking about other stuff here too. This is Glanville violated Thug's constitutional right to confront prosecutorial misconduct when lawyer Hilton introduced a known, void, null, invalid, involuntary guilty plea before the jury. So this is when Hilton was examining Detective Rossi. I barely remember this. He didn't go on camera, if I remember that correctly. But about an invalid, void, involuntarily guilty plea, knowing that same does not exist under law to push the prosecutor's invalid theme that Mr. Winfrey was protecting the supposed purported gang members now on trial at the case at bar. I'm confused. That's like the first reference to Jimmy Winfrey there, but I don't see a full first reference before that. It's a little confusing. Sometimes these motions get a little confusing to read. The federal court documents are a little cleaner, but the recused judge refused to permit undersigned counsel to confront Detective Rossi and prove that lawyer Hilton was eliciting non-factual and knowing misleading testimony to the jury. This denied Mr. Williams his constitutional right to cross-examine witnesses. So these are a lot of new arguments, obviously outside of the ex parte, but this is kind of his new chance to, Brian Steele's new chance to unload to the new judge before the big hearing starts on Tuesday. It says lawyer Love has attempted to demonize counsel for Mr. Williams as well as the other accused counsel in front of the jury. This appears to potentially be lawyer Love's standard practice. We should read this. Oh, they've got the article attached about the lawsuit. Oh, the appeal. I used to know the editor that. He's not the editor anymore, but the appeal does some good work. But medical staff at notorious Atlanta jail let autistic teen waste away and die, lawsuit says. I wonder what it says about there. Prosecutorial misconduct has been perpetuated by lawyer Love from the inception of this case in order to goad Mr. Williams into moving for a mistrial. The above few samples prove in the event of any wrongful conviction of Mr. Williams, there is a substantial likelihood of reversal by an appellate court, including a court presiding at a motion for new trial. Therefore, the continued incarceration of Mr. Williams is punitive without legal justification. This past month and a half alone finds Mr. Williams helplessly trapped in a cell based upon the intentional misconduct of lawyers Love and Hilton and the recused judge. This delay in causing this honorable court to parachute into the case has infringed upon Mr. Williams' freedom. Respectfully, bond must be granted. This continued incarceration of Mr. Williams is unconscionable, as has much of this trial under the guiding hands of the recused judge and lawyers Love and Hilton. The prosecutors and recused judge's misconduct and trampling of Mr. Williams' constitutional rights has forced Mr. Williams to timely move for several mistrials after being goaded into the same. This trial is not fit for a kangaroo. So yeah, again, this all depends on the judge, the new judge, Judge Whitaker, being willing to re-examine Judge Krause's assessment of the ex parte, because no judge has actually found misconduct by the prosecutors, and arguably, I mean, Judge Glanville was recused for the way he responded to the recusal motions. So it wasn't related to the ex parte. So it's really important, if they want any chance of these motions passing, they have to hope that Judge Whitaker is going to agree with them and feel like she can go back and say, actually, Judge Krause was wrong. I think the ex parte was wrong. And I'm not sure, that's kind of a tall ask of Judge Whitaker, but we'll see what happens next week. Like I said, they're all going to be back in court on Tuesday at 8:45 a.m. Atlanta time. Mr. Williams lawfully filed a statutory demand for speedy trial. No reasonable person would argue that a speedy trial has been satisfied. Yeah, I'd say that's true. God, 2,000 potential jurors. That's insane. Yeah, the jury selection lasted so long. That's what he's writing about here. This continual waste of time has caused Mr. Williams to be wrongly denied freedom in a fair, speedy, constitutionally sound trial. Yeah, Glanville just was in way over his head with a case of this size. Like, clearly, I mean, I think it's kind of unprecedented for all of them, but we'll see. Oh, there are a bunch of different arguments in here. Oh, yeah, so it's 14 pages and then a lot of exhibits. But yeah, so the mistrial and the mistrial requests obviously are the big ones here, because but there's such a urge here and a desire to find the prosecutorial misconduct, and so they can get the mistrial, the can't retry them finding. But I'm not sure. It might be kind of a tough ask, but we'll see. Again, it's next Tuesday at 8:45 a.m. That's 5:45 a.m. in Atlanta, or in Los Angeles. I'm planning on watching, and I'll be streaming online and everything, and we'll keep it updated. If there's no gag order issued, hopefully we can do some more interviews with the attorneys. But thank you guys, and thanks for all the love, everybody. If I need to get a little better at responding to the chats, I got to get a moderator in here to see everybody. Yeah, Mallory, I know it's exciting. Like I was telling Doug in a previous interview that the case has gotten a lot more interesting now. I mean, it used to be like a few months ago, we were hearing about a Nissan crashing into the side of a laundromat. And it was just like that kind of testimony over and over and over again. But now we've actually got some legal intrigue and like, how is a judge going to take over a trial like this, like in the middle of it, you know? So yeah, I'm really looking forward to see how Judge Whitaker responds or handles any of this stuff, because I think especially Bruce Harvey's motion for mistrial is pretty hard to argue with, but where he just argues about like how could a new judge take over a trial like this 19 months in, but with the other lawyers not supporting it because of the lack of a with prejudice finding, I mean, that kind of gives the judge a reason not to grant it, I guess. But I mean, I don't know. She seemed totally gung-ho in the first time we saw her in court last week, that, you know, she was just going to gung-ho move forward with this. But we've got a few things to work out before then. So anyway, it's Friday. Everybody should go kick back and have fun and enjoy the day. I'll definitely be back next week streaming, and check out Thugger Daily for links to all the documents. Toria, I'm so glad to hear that you're listening on the drive home. Yeah, I'm so glad to update you all. We've got motions for bail, motions for mistrial. We've got some big stuff coming up. Disqualified prosecutors, Love and Hilton, that still hasn't been dealt with. Young Thug is asked to strike all of Woody's testimony from June 12th onwards, which is like basically everything. Motion for bond. And they want to, and he and Yak Gotti have both asked Judge Whitaker to rescind Judge Krause's order that the ex parte was proper. So that's a big one. I think that's the biggest one that'll tell us how things are going to go. So, Mallory says she'll be up at 5:45 a.m. on Tuesday. Yeah, I'm going to get up that early too. I'll have to get up a few minutes earlier to man the feed, but that's before the coffee shop's even open. But it's gonna be killer. But I've got some other stuff going on, so stay tuned this weekend. I've got some other news and some other cases. So anyway, I will see you guys later. Thanks so much for everything.